Morning, everyone. We'll get started in a few minutes. Good morning, all. This is Kristen O'Neill with the New York State Committee on Open Government. If someone wouldn't mind just sending me a note in chat, because this is sort of a one-way street, that you can hear me. I think that's good. I got a hi. So, oh, awesome. I'm getting some yeses, so no one else needs to reply. I just wanted to double check. Last time I did this, I had something go wrong with my sound, and I just wanted to double check before we got going. Thank you, everyone, for joining me today. We're going to do an overview of the Freedom of Information Law and sort of go over a few things that have maybe not even are new. A few things might be new, but mostly just some issues that have come up significantly in the past year, or at least in the past couple months. I just wanted to go over and focus on. Some of it has to do with judicial decisions, either clarifying the statute or providing additional guidance regarding obligations under the statute. So we'll talk about a couple of those things. As we go along, you're welcome to put questions in the chat feature. And what I will do is at the end of the program, I'll go through the chat and address any questions that come in. In addition, I want to let everybody know that copies of the slides, this was the first time I did this with WebEx, but copies of the slides should be have been provided to you through the WebEx link, but also they're available, similar versions are available on our website. We have a section of the Committee on Open Government's website, which is opengovernment.ny.gov, as you can see right now. opengovernment.ny.gov is our website, and on that website there's a section that says I would like to view training materials, and that brings you to recordings of these programs. Actually, that just reminds me, I want to make sure recording is already in progress. Someone's asking me to turn up the volume. I don't think I can turn up the volume on my end. You may have to turn up the volume on your end. I don't think there's really anything more that I can do on my end for you. Fortunately, just sitting right in front of the laptop, that's just a one-way street. So on that website, there's recordings of past FOIL and open meetings law programs that I've done. In fact, this program is being recorded and will get posted on our website within the week at the end. So if you miss part of it, or if you If you have friends that you think you want to pass this along to, then I'm going to put a note in something because people are telling me that they don't have sound, but just a second. Be with you in just a second. All right, thank you all for being patient. Sometimes when you're doing these one woman shows, different things come up and you try to multitask. So, as I mentioned, my name is Kristen O'Neill. I'm the Deputy Director and Counsel for the Committee on Open Government. I'm also in charge of training for the Committee on Open Government. So whenever anyone requests a training for their municipality, for their agency, maybe they have an open government group, or they have maybe a media organization. I've had requests from universities. I really just any sort of organization that works with FOIL or the open meetings law, we're happy to come in and talk to your group, your government agency, whatever the case may be, to provide guidance regarding either the Freedom of Information Law or the open meetings law. So that's sort of a big picture issue. We do these training programs. And in addition, we have day-to-day responsiveness to inquiries that come in about either someone from the public who is trying to make a Freedom of Information Law request, or you are an employee of a government agency who is attempting to comply with the Freedom of Information Law. And you need guidance on that from that side. So anyone is welcome to call our office to request that type of guidance. And you can call us at the phone number that's up on the screen right now, that 518-474-2518, or you can email us at COOG, which is our acronym for Committee on Open Government, at dos.ny.gov. We also have a lot of helpful information on our website. We have a copy of the statutes, with the regulations. We have advisory opinions that are indexed alphabetically by key phrase, but are also searchable by key phrase. And we have our past annual reports that talk about sort of big ticket issues in the world of open government. And anytime something significant comes up with either Freedom of Information Law, the Open Meetings Law, we do try to get that right up on our homepage of our opengovernment.ny.gov website. If you've heard rumblings that maybe there was an amendment to the statute and aren't sure, good place to start is our website. So, FOIL is codified in public officers law, so sometimes you'll see references to public officers law Article 6. That is where the Freedom of Information Law is codified. This is a generic version of what our website looks like. So if you go here, you're going to find information that top of the screen bar, the Freedom of Information Law, Open Meetings Law. Those are drop-down menus, so you can go in there, and there's some helpful information that you can find in those under those drop-down menus. FOIL was enacted in 1974, was fairly limited in scope. You could only have access to 9 categories of records. That version was repealed and replaced with a current version that is based on a presumption of access. So what does that mean? Whenever an agency receives a Freedom of Information Law request for records, they should assume that those records are available to the public unless they can assert one or more of the statutory grounds for denial. So I often get questions such as, is this FOILable? Is this a public record? And I encourage, if it's an agency that's asking for that information, I encourage them to flip that question flip that question in their minds and instead say, is there any ground for denying access to this record? You should always assume that any record that an individual is requesting is FOILable, which is sort of a description that has become a common word in our vernacular, I guess. It is FOILable. It is public unless you can assert one of the grounds for denial. Who's covered by FOIL? You've heard me use the term agency a couple times. And when I use that word agency, I don't just mean, for example, state agencies. I don't mean the Department of State, Department of Health, Department of Labor. I also mean that the term agency is defined by the Freedom of Information Law. It means any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or for any one or more municipalities thereof. So essentially, this means everything from, the governor's office, again, the Department of State, Department of Health, Department of Labor, all of those state level executive agencies are subject to FOIL. The Office of the Attorney General, the Office of the State Comptroller, and then you work your way down. You've got county level government, you've got city level government, towns, villages, school districts, got fire districts, water districts, sewer districts. Their libraries, public libraries, I should say, are subject to FOIL. There are thousands of units of local government in the state of New York that are all considered agencies that have to comply with the Freedom of Information Law. Who is not an agency subject to FOIL? The judiciary, meaning the courts. The courts are not subject to FOIL. You cannot make a Freedom of Information Law request to the courts for court records. Doesn't mean many of those records aren't publicly available. It's just that Freedom of Information Law is not the appropriate mechanism for accessing them. FOIL does govern access to state legislative records, but they're not an agency as that term is defined by FOIL. There's no presumption of access to state legislative records. But with the state legislature, it's more similar to that 1974 original version where the law provides a list of the types of records that you can access under the statute. And if you don't see it on this list, it's not available under FOIL. Every agency that is subject to FOIL is required to appoint someone or one or more people to serve as records access officer. And the position of records access officer the term is never used in the statute, but it's established by regulations that are promulgated by the Committee on Open Government. And those regulations have the force and effect of law. So every agency is required by law to have a records access officer, at least one, maybe more, depending on the size of your agency. So the agency itself has a legal responsibility for ensuring compliance with the law and regulations, but the records access officer is the person that's either designated by name or by job title, and is the person to whom FOIL requests must be directed by mail and by email. And that person has the duty of coordinating the agency's response to public requests for access to records. What is a record? A record is any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. It's an incredibly broad definition. If you can see it, if you can feel it, if you can hear it, it's probably a record subject to FOIL. It's information in a physical form that's either kept, held, filed, produced, or reproduced by, with, or for an agency. So this includes not just records. For example, if you're talking about, let's say you're talking about town government, these are not just records sitting in the town clerk's office. These are emails possessed by town board members. These are personnel records that are sitting in the supervisor's office. These are records that are maintained by the town attorney on behalf of the town. So it's incredibly broad, and there's a non-exhaustive list of examples within the statute, but it's essentially, when we're talking about access to records under the Freedom of Information Law, it's very, very broad. However, an agency is not required to create records in order to respond to a Freedom of Information Law request. FOIL does not obligate an agency to answer questions or to manually create a new record in order to provide information. So if someone sends an email to the records access officer and says, I'd like an explanation as to why the town board made this decision, that is not a FOIL request. And while we as government employees answer questions all the time, it is not an obligation that we have under the Freedom of Information Law. Under FOIL, a person has to reasonably describe the records that they are seeking, and they have to request access to existing records, records that exist at the time the FOIL request is made. Making a copy of an existing record does not constitute creating a new record. So if you only have records in paper form and someone would like you to scan them and create an electronic record, if you're a government agency, and so someone says, I would like you to email me these records, you have the ability as an agency to scan those records and provide them electronically. That's not creating a new record. It's simply making a copy of an existing record. In addition, any programming necessary to retrieve a record maintained in a computer storage system and to transfer that record to the medium requested by the person, or to allow the transferred record to be read or printed, shall not be deemed to be the preparation or creation of a new record. So data extraction is not creating a new record. If the information is contained within the database and it can be extracted into a format that is accessible to the public, that's not creating a record by statute. So you see number 5 up on the screen right now. That's not something I just, made up, pulled out of the air. That is statutory language. It shall not be deemed to be the preparation or creation of new record. An agency is required to provide records on the medium requested by a person if they can reasonably do so, either in-house or by engaging in outside professional service. So again, this goes to, for example, if someone wants the records electronically and you have the ability to make electronic copies, as an agency, that agency would be obligated to do so. Another example is if someone would like records in their original format, such as Excel. Sometimes you've got data that exists in an Excel database, and the person doesn't want that Excel database converted to an Adobe PDF file. They want the original Excel database. As a government agency, you'd be obligated to provide them the Excel database. Or excuse me, I don't mean to say database, that's not the correct term. Data sheet, data worksheet. You're required to provide that original version. There are 3 records that the Freedom of Information Law requires every agency to create, maintain, and make available to the public. One is a record of votes of each member in every session, in every committee and subcommittee meeting in which the member votes. So go back to county government. If you have a town board, every town board meeting, in addition to the obligations under the Open Meetings Law that says you have to have a record of every record or summary of all motions, proposals, or any other matter formally voted upon and the vote thereon. So the Open Meetings Law doesn't necessarily require that you have a specific record of how each member voted, but the Freedom of Information Law does. So under the Open Meetings Law, the minutes could simply say, the motion passed 3-2. But under the Freedom of Information Law, there's an obligation to say which 3 members voted in favor and which 2 members voted against. The second record that every agency is required to maintain is a record setting forth the name, public office address, title, and salary of every officer or employee. So that's public office address, not home address. So for example, the Department of State, we have multiple locations across the state. So the Department of State would be required to have all the names of its employees, whether they, for example, work in Buffalo, or do they work in Albany, do they work in New York City, the physical address of where they work, their title, and their salary information. That's required for every agency subject to FOIL. That's public information. In addition, a current list that is reasonably detailed by subject matter of any records required to be made available for public inspection and copying pursuant to this section Municipalities frequently adopt the record retention and disposition schedule established by the New York State Archives as their subject matter list. Recently, we had an inquiry about school districts because a couple of years ago, the New York State Archives consolidated the separate retention and disposition schedules. There used to be one for local government, or like, cities, towns, villages. There's one for counties, and there's another one for school districts. And now they've all been consolidated into one. So a question came up recently because there's a feeling, I believe, that the LGS one doesn't really accurately reflect, for example, the records that a school district maintains. So I would just encourage, if you do work for a school district, you want to take a close look at that LGS one to see if you feel that really accurately reflects a reasonably detailed subject matter list of the records that's maintained by your district. When a person makes a FOIL request, any individual who wants to make a FOIL request, they have fairly few obligations on their part. One is that they have to put the request in writing. Well, they can be required to put the request in writing. Not that an agency isn't free to accept an oral request for records if they want to, but they are permitted to require written requests. They do not have to accept verbal requests for records. So the request could be in writing, and the person who's making the request has to reasonably describe the record sought. They have to provide enough specific information so that the agency can identify the record sought and locate the record sought based on their record keeping system. So sometimes whether a person has reasonably described the record sought is going to depend in part on how the agency maintains its files. So for example, if all of your files are, an agency's files are maintained alphabetically by last name, providing somebody's first name is not going to be useful at all. You may have records relating to John, but unless you dig through maybe thousands and thousands of records, you're not going to be able to find those records. On the other hand, if someone says, I would like all records relating to John Doe, okay, well, that might make it a little bit easier. But even then, you might need to provide additional information. Maybe you're going to need to provide a date of birth or some other identifying factor that allows an agency to locate the records you're seeking with reasonable effort. Very old Court of Appeals case law basically indicates that an agency is not required to search for a needle in the haystack. So again, if you make a FOIL request, say I'm looking for records relating to somebody named John, that's probably not particularly helpful, and no agency is going to be obligated to go look through all of their records for records relating to somebody named John, if that's not how they maintain their records, if they are not able to search by first name. And of course, the answer may be different depending on whether the records are paper or electronic. It's much easier to search electronic records than it is to search paper records. Time limits. Every agency subject to FOIL is obligated to respond to a FOIL request within certain time limits. The first time limit that comes into play is 5 business days. Within that first 5 business days of receiving a request, so for example, today is Tuesday, February 4th. If someone receives a FOIL request today, no later than next Tuesday, February 11th, someone has to take some type of action. They need to either provide the record that's being requested, they need to deny access to the record being requested. They could state, we don't have the record that you're requesting, we don't possess it, or we cannot locate it after a diligent search. Or the fourth option is to acknowledge receipt of the request and state you need more time. If you need that last option, you need to give a time by which you plan to respond. If you're a government agency, the agency has to give an approximate date by which it plans to respond. In general, the way the statute is written, there's an expectation that 20 business days is an acceptable amount of time for an agency to process a FOIL request. That's sort of the default. If an agency can respond to a request within 20 business days of acknowledgement, it's probably on pretty solid ground. However, the law gives some wiggle room. If an agency requires more than 20 business days to respond to a FOIL request, it is permitted to take that additional time, but it has to notify the applicant either at the time of the acknowledgement, or if the acknowledgement stated, we hope to get back to you within 20 business days, and the expiration of that 20 business days is coming up, and the agency realizes it needs additional time, the agency can then send out another letter stating, due to these extenuating circumstances, due to these circumstances attending this particular request, we need more time. And we're giving you a date certain that is reasonable under the circumstances of this request. If you need more than 20 business days as an agency, the agency is obligated to provide both that date certain that's reasonable under the circumstances and a reason for the delay. The reason might be the volume of requests that it's processing as a whole. Could be the volume of this particular request, the complexity of this particular request, if it's a particularly voluminous request. Another time limit that comes into play, if an agency denies access to a request, the applicant has 30 calendar days to appeal that denial. Once an agency receives the appeal, they have 10 business days to respond to that appeal. Agencies must accept requests via email. Agencies cannot require a requester to use its form, and this includes electronic forms and portals. While it's lovely that many agencies are offering these electronic forms and portals for submitting FOIL requests, an agency cannot require an applicant to use those forms and portals. And the reason in part is because these forms and portals require much more information than the statute allows an agency to require. The law only requires that the request be in writing. That's it. It doesn't require that the requester provide their name. It doesn't require that the requester provide their address. It doesn't require that the requester provide their phone number or email address. Of course, many requesters are going to provide that information because it provides an avenue for getting a response back, obviously. But forms that are made available to the public, again, there's nothing wrong with making it available. There's nothing wrong with having it as an option. But what is wrong is basically not providing the applicant an avenue for submitting FOIL requests by email that don't involve using those electronic forms and portals. Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. If an agency receives a FOIL request from a John Doe or completely made up silly name, it doesn't really matter, no name whatsoever. If they receive a request via email for a record that would be publicly available to anyone that asked for it, they must respond via email, if possible, to that person and provide access to the record that's being requested. It does not matter if they provide their name or identifying details in that request, unless there are personal privacy concerns relating to the request. For example, if someone's asking for a law enforcement incident report, if someone is asking for social services records, which to some extent obviously is confidential by other statutes other than FOIL. If someone is requesting names and addresses of individuals where they want to use the information for solicitation or fundraising purposes, there are certain circumstances where there are personal privacy concerns that are raised by the records, by the content of the records. And if the person who is seeking those records wants those records or wants those records in an unredacted form, they may need to provide their identity. But on the other hand, if someone's asking for a contract, financial records, things of that nature, that are publicly available to anyone, they should be permitted to remain anonymous. Next couple of slides go through most of the statutory grounds for denial. We're not going to go into great detail about every single one. I'm just going to kind of do a surface coverage of some of them, maybe a little bit of a deeper dive on some of the ones that come up more frequently. There are some additional grounds for denial that relate to provisions of vehicle and traffic law, like, for example, red light cameras, and I think that the school bus cameras and things like that. Those tend to be, there are provisions in vehicle and traffic law where those records are not obligated to be made public under the Freedom of Information Law. Here we're going to start talking about some of those grounds for denial. The first is the only ground for denial, essentially, that's mandatory. When access to a record is governed by a statute other than the Freedom of Information Law, where a record is exempt from the Freedom of Information Law by either state or federal statute, an agency is required to comply with that separate state or federal statute. It's not discretionary. So some examples of non-discretionary: someone makes a FOIL request to a school district for a particular child's student records, a child that's not their own, a child that they are not the parent of, a child that they are not the guardian of. They want someone else's student education records. Those records are confidential pursuant to the federal Family Educational Rights and Privacy Act, or otherwise known as FERPA. That statute, that federal statute, prohibits disclosure of student education records to anyone other than a qualified individual, such as a parent or guardian. Attorney-client communications are confidential by statute, and unless an agency wants to waive the attorney-client privilege, they need to assert that attorney-client privilege to the records that are being requested that are covered by that privilege. If they disclose those records, they are waiving the attorney-client privilege. So in order to maintain that privilege under the civil practice law and rules, they need to withhold those records under FOIL. Mental health records: I used to work for the Office of Mental Health. Sometimes we would get a FOIL request for someone's psychiatric records, and the immediate answer is no, this is not the appropriate mechanism for obtaining those records. Because, to be honest, as an individual who worked in counsel's office at the Office of Mental Health, if it was not even any of my business whether somebody had psychiatric records, I didn't have access to that information. So I certainly wasn't going to go to one of our hospitals and say, hey, do you have this person's psychiatric records, and then turn around and deny access. I just immediately said, no, those records are exempt from FOIL disclosure under both state and federal statute. Another example is autopsy records. There's a provision of New York State county law that makes autopsy records confidential. Those are prohibited from being disclosed under FOIL. Phone recordings and transcripts of phone calls made to county-operated E911 systems are confidential pursuant to New York State county law. An agency is prohibited from disclosing those records under the Freedom of Information Law. Disclosure of Social Security numbers is prohibited pursuant to Public Officers Law, Section 96. So if you have a record that contains somebody's Social Security number, as an agency, you want to make sure you're always redacting that. And there are dozens and dozens of examples, other examples of confidentiality statutes. There's tax secrecy laws. There are records that govern access to vital records. There are social services provisions. There are, as I said, dozens of statutes that confer confidentiality on certain records. And when that separate statute exists, the agency wants to make sure that it's complying with that statute first before it even thinks about FOIL. So that's situations where an agency is required by law to withhold. The rest of these examples are permissive. An agency is permitted to assert one of these grounds for denial, but is not required to. One example of that is when disclosure of a record would constitute an unwarranted invasion of personal privacy. A side note here is while under FOIL, disclosure of records, which if disclosed would constitute an unwarranted invasion of personal privacy, under FOIL, it's permissive to withhold. But if you are a state agency, you are required to comply with another statute, the Personal Privacy Protection Law. The Personal Privacy Protection Law prohibits a state agency from disclosing records where disclosure would constitute an unwarranted invasion of personal privacy. And again, where I'm talking about state agency here is I'm talking about agencies like essentially under the governor's office or the office of the attorney general or the office of the state comptroller. We're talking about the Department of State, Department of Health, Department of Labor, Office of the Attorney General, Office of the State Comptroller, State Education Department. Those agencies are required to comply with the Personal Privacy Protection Law. Local government entities, such as counties, cities, towns, and villages, are not required to comply with the Personal Privacy Protection Law, but they are permitted to assert unwarranted invasion of personal privacy as a ground for denying access to a record in whole or in part. Some examples here are employment applications of individuals that were not hired for a public position. So you had a government agency had a job opening. They received 20 applications. Of course, only one person is hired. Someone wants to make a FOIL request for all the job applications for the people that were not hired. The agency is permitted to either redact the resumes or applications sufficiently to protect those individuals' identity, or if that's not possible, they can withhold the resume or application in its whole. I use myself as an example because I sort of have a one-off job, so to speak. Committee on Open Government itself is very small. I'm the only person that has served as, deputy director, assistant director of the Committee on Open Government for the past 10 years. So it's very difficult to disclose my resume without identifying myself. So if I want to apply for another job, that other agency would likely just withhold my resume in its entirety because disclosing it, even a redacted version, would tend to identify me. Home telephone numbers, personal cell phone numbers can be withheld. Medical information, and here I'm not talking about information that's governed, where access is governed by the HIPAA privacy regulations or public health law or mental hygiene law. I'm talking about information that might be in a public employee's personnel file. Maybe they had to be out on workers' comp or FMLA, and there's medical information contained in their files. Information of that nature could be withheld because disclosure would constitute an unwarranted invasion of personal privacy. Public employees' home addresses can be withheld. Lists of names and addresses of natural persons, if that information is going to be used for solicitation or fundraising purposes, can be withheld. Mugshots can be withheld. So here I note that public employees enjoy a lesser degree of privacy than others. So there's a lot of information about public employees that can be disclosed or must be disclosed that wouldn't be disclosed if you worked in a private setting. So for example, as a current employee, if someone came to the Department of State and made a Freedom of Information Law request for my resume or my job application, a lot of that information within that file, a lot of the information in my personnel file as a whole would need to be disclosed. Anything that shows that I am qualified to do the job that I've done, anything that relates to my ability to do my job, my qualifications, or how maybe well or not well I've done my job. If I have engaged in any misconduct and there were disciplinary actions taken against me, that's information that would need to be disclosed. On the other hand, if an allegation of misconduct was made against someone, an investigation was conducted, and it was determined that that person did not engage in that misconduct, the agency may determine that disclosure of records relating to those unfounded allegations of misconduct would constitute an unwarranted invasion of personal privacy. Here, I'll note that in the fall of the past year, in fall of 2024, there was an amendment to the Freedom of Information Law that requires that all agencies subject to FOIL must develop a policy regarding providing a notification to its public employees in the event that the agency is responding to a request for the employee's disciplinary records. I don't include it in these PowerPoints, but on our website, we prepared an advisory opinion that attempts to give some guidance about what we believe the legislature intended with this amendment, about in terms of timing, about what does this mean about what's a disciplinary record, what's included in that, the timing, uh, should it occur before or after the disclosure? There's just a couple of questions that we received that at the time that this law was passed that we attempted to address in an advisory opinion. So if you want to go look at that, that's FOIL Advisory Opinion 19867, and it's available on our website. Another example of a permissive ground for denial, a permissible ground for denial, is when disclosure of a record or a portion of a record would impair present or imminent contract awards. An agency can disclose records or portions of records, which if disclosed would impair present or imminent contract awards or collective bargaining negotiations. And here the key word is impair. Would disclosure of the record give one party an unfair advantage over another, or put the government agency that possesses the records in a weakened bargaining position? If you're talking, sometimes we have situations where contract's been awarded and several years have gone by, maybe 4 or 5 years have gone by, and it has to go out for bid again. Has to go out for bid, another RFP, another request for bids has to go out, and a FOIL request is made for the current contract terms. Some agencies have attempted to withhold the current contract on the ground that, well, if we let everybody know what the current contract is, it could impair present or imminent contract awards. And that has repeatedly been shot down. The Committee on Open Government has offered opinions, but also the courts had said, no, you can't withhold information relating to a current contract when a new contract is being put out for bid. Trade secrets are substantive competitive harm. An agency can withhold records or portions of records which are a trade secret, and trade secrets are sort of defined by the courts. And or it could be a trade secret, or it could be information submitted to an agency by a commercial enterprise or derived from information obtained from a commercial enterprise, which if disclosed would cause substantial injury to the competitive position of the subject enterprise. So essentially those are almost two different things. It can either be a trade secret, or it can be information which if disclosed would cause substantial commercial injury to the competitive position. They may line up sometimes, they may sometimes be in the same bucket, but sometimes something is not a trade secret, but still would cause substantial injury if disclosed. At the state level, there's a specific statutory process that has to be followed in order for a record to be afforded trade secret protection. But at the local level, an agency has to establish its own process. But ultimately, every agency is going to have the burden of defending non-disclosure. Interagency and interagency material. This ground for denial is intended to protect the deliberative process. An agency is permitted to withhold communications, records, draft documents that reflect advice, opinions, recommendations, subjective thoughts about a particular topic. But within those intra-agency and interagency material, what an agency is required to disclose is statistical or factual tabulations or data. And I'll let you know that the courts have interpreted that term pretty broadly to mean almost any objective information, not just numbers. It's not just data, it's objective, factual information. Instructions to staff that affect the public. So if a guidance document goes out from the head of an agency to its employees, for example, and the content of that guidance document affects how the public interacts with that agency, that's something that would need to be disclosed. Final agency policies or determinations need to be disclosed. So if there's a finding of misconduct against a public employee, so a letter goes from the Human Resources Department to an employee advising them that there's been a finding of misconduct and here's the disciplinary action that we are taking against you, that's a final agency policy or determination. And to a large extent that would need to be disclosed unless there's information that could, where disclosure would constitute an unwarranted invasion of personal privacy, maybe against another party. External audits, including audits conducted by the Office of the State Comptroller. So here, interagency or communications between or among the employees or officials of a single agency. So for example, I work for the Department of State. I work within the house within the Department of State. If I email my boss or one of my coworkers, that's an interagency communication. If someone who works for town government emails me at the Department of State and asks for my advice about a FOIL request and I respond by providing that advice, that's interagency material. The Office of the State Comptroller is an agency subject to FOIL. However, the law states that external audits, including audits conducted by the State Comptroller, must be disclosed. So that's sort of that exception to the interagency material exception. Question that has, or an issue that has come up in the past couple of years, I'm going to say, it came up because the Appellate Division First Department had started to issue, and as of this time, maybe it's even up to 5, has issued 4 or 5 appellate level decisions relating to rights of access, where the First Department has held that an agency is only obligated to redact a record when the redactions are based on personal privacy. First Department went on to say that if you have a record that contains both exempt and non-exempt material, unless the exempt material is being withheld on personal privacy grounds, there's no obligation to redact. This is completely 100% inconsistent with long-standing binding Court of Appeals precedent on this issue. We prepared a lengthier than what you see on the screen, I should say, advisory opinion. So if you have questions about that, please look to FOIL Advisory Opinion 19866 for additional guidance. But I'm going to give you the thumbnail. If a record contains both exempt and non-exempt material, the agency, first option, must withhold the record if in its entirety, if it's exempt from FOIL disclosure by state or federal statute and access is governed by that separate statute. So for example, if someone makes a FOIL request for a mental health record, it's required to be withheld in its entirety. If someone makes a FOIL request for a student education record, it's required to be withheld in its entirety. An agency is not required, nor should it redact that record in order to disclose. It just withholds it in its entirety because access to that record is governed by a separate statute. The second option is an agency may withhold the record if disclosure would constitute an unwarranted invasion of personal privacy. But the disclosure shall not be construed to constitute an unwarranted invasion of personal privacy when identifying details are deleted. So another example here is if you have a record, let's say you've got a witness statement. It's law enforcement and you have a witness statement. And the witness statement could be disclosed and there would be no unwarranted invasion of personal privacy if you just redact the name and identifying details of the witness. if you believe, as the law enforcement agency, that disclosure would cause harm to that witness. The third scenario is when you have records that are exempt from FOIL disclosure, and they contain both exempt and non-exempt material. An agency may redact the portions that are subject to one or more of the permissible grounds for denial, but must disclose the remaining portions. So if you have intra-agency material, for example, and you have an email communication, and the email communication contains advice, opinions, recommendations from an employee to their supervisor. The advice, opinions, recommendations can be withheld, but if that employee, in support of their opinions, their recommendations, included statistics or facts that support that opinion, the statistics and facts need to be disclosed. So just a reminder that there is an obligation to redact when a record contains both exempt and non-exempt material, unless access is governed by a separate state or federal statute. Certification. There are two situations in which an applicant for records has the right to request a certification. When an agency indicates that it does not maintain or cannot locate a record, an applicant for that record may seek a certification to that effect. The statute states that upon request, an agency shall certify that it does not have possession of such record, or the record cannot be found after conducting an diligent search. The second scenario is when an agency provides a copy of a record, the applicant may request a certification that the copy provided is a correct copy of the original. This is not a certification that the content of the record is accurate, but simply that the copy is a true copy of the original. The copy looks exactly like what is maintained by the agency. All right, appeals. There are circumstances that give an applicant the right to appeal a denial of access. The first general and probably most common scenario is when there's an express denial of access, an affirmative denial of access. The agency says, we've received your FOIL request, we have the record that you're asking for, but we are withholding it in whole or in part. This could be as simple as redacting one single word, or it could be as broad as withholding the entire document or record. When that happens, an agency is obligated to provide a reason for the denial and advise the person that they have the right to file an administrative appeal within 30 calendar days and to whom that appeal should be directed. Another situation is when there's a constructive denial of access. And this is when the agency fails to respond to a request within the time limit set forth in the statute. So if an applicant provides, the person who's requesting records submits a FOIL request, and 5 business days comes and goes and the agency fails to even acknowledge the request, that's a denial of access under the statute. And the person who makes the request has the right to file an administrative appeal. Maybe the agency acknowledged the request, said we would get back to you within 20 business days, but failed to do so. Again, that's a constructive denial of access that gives rise to the right to an appeal. Another situation that could come up is where the agency receives the request, acknowledges receipt, and gives a date certain that the agency believes to be reasonable given the circumstances. Of course, as we all know, the term reasonable is subjective. What one person might consider reasonable, another person might consider to be completely unreasonable. If the applicant who submitted the request believes that the date certain that the requester was provided is not reasonable given the circumstances of the request, they have the right to challenge that date. And that they can treat it as a constructive denial of access and challenge that date and have the appeal officer review it and determine whether the date is reasonable under the circumstances. The FOIL appeals officer is the head or governing body of an agency, or the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same person as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial. And sometimes it's a combination of both of those things. The law does not contemplate a remand back to the records access officer. Under the statute, it is the responsibility of the appeals officer to review the records at the appeal level and to either provide access to them or to explain why they're continuing to be withheld. An agency is required to send a copy of both the appeal and the appeal determination to our office here at the Committee on Open Government. We encourage agencies to take advantage of email for this purpose. We love electronic records, makes record keeping a little bit simpler. So if you'd like to, as a government agency, email us copies of your appeals and your appeal determinations, we would be very happy to accept them that way. If you work for an agency, keep in mind you're not required to send us copies of any responsive records that may end up getting disclosed. We just need the appeal and the appeal determination. Fees. Under FOIL, there are two fee structures. These fee structures cannot be combined. It's one or the other. The first is photocopies. And this is becoming less and less of an issue as we progress through, we're into the 25th year of the 21st century. It's becoming less and less of an issue. But if someone wants photocopies of a record that is up to 9 by 14 inches, the agency is permitted to charge 25 cents per photocopy. The agency cannot charge, when they're providing photocopies, they cannot charge for search time, they cannot charge for administrative costs, they cannot charge for the time it takes to review the records, to determine rights of access, or to apply redactions. All they're allowed to charge for is 25 cents per photocopy. The second fee structure is for anything other than photocopies up to 9 by 14 inches. And this could be something larger like maps or blueprints, or it could be records in a completely different format. Like it could be when an agency is scanning records. It could be when an agency is doing a data extract. It could be making a copy of an audio or a video. If you need to take advantage of that separate fee provision, in determining what the actual cost of reproduction is, because that's what the law says the agency is permitted to charge, the actual cost of reproducing the record. So keep in mind here, look at the language. It's the actual the cost of reproducing the record. It's not the cost of processing the FOIL request. There are lots of work that goes into receiving, responding, and processing FOIL requests. They're just simply not a reimbursable cost. The only thing an agency is permitted to charge for under certain circumstances is the cost of making the copy. So what does the law state you're allowed to consider when determining the cost of making the copy? One factor is the hourly salary of the lowest paid employee capable of making that copy, but only if it takes at least 2 hours. So for example, if you're scanning paper records, or if you're doing a data extract and it only takes you 20 minutes or an hour, no charges. The agency is not going to be able to pass along a cost. Once the agency hits that 2-hour mark, they can start charging. So if it takes someone 2 hours to scan records and they get paid $15 an hour or $20 an hour, let's say, then the agency can charge $40 for the cost of making the copy. If you need to place records on an electronic storage device like a CD or a zip drive, whatever that storage device costs your agency, you can pass that cost along to the applicant. If you do not have the technological capability of making the record in-house and you need to send it out to a third-party vendor, as an agency, you can pass along the cost of having the copy made by a third-party vendor. Maybe you need to send it out to Staples or something of that nature. Whatever the third-party vendor charges you, you get to charge the applicant. Also, just as I said for photocopies, an agency cannot charge for search time, cannot charge for administrative costs, cannot charge for time it takes to review the records to determine rights of access or to apply redactions. Can only charge for the time it takes to actually physically make the copy. The law requires that if you're going to, if you're using this second fee structure, this actual cost of reproduction, anything other than photocopies, the law actually mandates that an agency let the applicant know what the fee is going to be before making the copy. I recommend that you do it regardless. I mean, if someone wants photocopies, and particularly if it's a large number of photocopies, it doesn't make a lot of sense for an agency to incur the cost of making those photocopies and then find out that the person who's making the request just simply doesn't want to pay that cost. But it's optional for photocopies. It's mandatory for everything else. So you need to, if you're going to have, it's going to take 4 hours to scan records or 4 hours to do a data extract at $20 an hour, you need to let the person know that it's going to cost them $80 to obtain these records and make sure they're willing to pay it before you incur that cost. If they agree to that cost, an agency is permitted to either get a down payment or the money up front. In addition, there is case law that indicates that if the person agreed to the fees, the agency makes the copies, and then the applicant essentially backs out and says, I changed my mind, I don't want to pay that fee anymore. The agency is permitted to not process any future FOIL requests until the applicant has basically paid their bill, has paid for the records that they told the agency that they're willing to pay for. A lot of questions have come up with situations such as the cost for redacting, particularly with body-worn cameras, because that's sort of an onerous task, and we understand that here at the Committee on Open Government. We certainly do. But there is case law there is appellate law from 2020 that says respondents cannot charge petitioner a fee for the costs associated with the review or redaction of body-worn camera footage. The Forsyth versus the City of Rochester cites to the matter of Time Warner Cable News versus New York City Police Department. And in the Time Warner Cable decision, the court held that the New York City Police Department may not pass the costs associated with reviewing or redacting footage requested onto the petitioner. So I just want to point out there is actual case law that addresses that situation. Real quickly, public authorities are almost like quasi-governmental agencies. They are established under New York State Public Authorities Law. There are state-level public authorities and there are local public authorities. In the spring of 2024, Governor Hochul signed Chapter 58 of the laws of 2024, amended the Public Authorities Law to clarify and reinforce the fact that state and local authorities are subject to both FOIL and the Open Meetings Law. It requires that they comply with FOIL and the Open Meetings Law, but it also requires that they have to stream all open meetings and public hearings on their website in real time, post video recordings of their open meetings and public hearings on their website within 5 business days of the meeting or hearing, and maintain those recordings for a period of not less than 5 years. So essentially, there's going to be an obligation, both under the Open Meetings Law, but both also that these public authorities are going to be essentially creating records that are then going to be subject to FOIL. So before I go to questions, I'm just going to remind people that the Committee on Open Government does not have enforcement authority. Enforcement of the statute is through a Civil Practice Law and Rules Article 78 proceeding. The statute states that attorneys' fees and other reasonable litigation costs can be awarded. They're mandatory when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. They're discretionary when the requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time limits. If you have any questions about anything we talked about today, you're welcome to contact our office by phone or by email. We're a small office. If you have a general question that it's not specific to something that I said today, just call the number, ask to speak with an attorney, or you can shoot an email to coog@dos.ny.gov and ask your question. The first attorney in our office that has an opportunity to do so will get back to you as quickly as possible. You're welcome to direct your call or email to me specifically if it has something to do with something that I brought up today and you want clarification. So I am just going to go to the, let's see, stop that. I'm going to, I am looking a little scruffy. Let's see, what I want to do is go to the chat feature. Hold on just a second. Where's my chat? There we are. Chat with the whole thing open. Okay. Making it as big as possible, sorry. I want this. All right. Hoping to make this a little larger, but I'm struggling a bit. So I'm gonna go through a few questions, people checking in, letting me know that the sound is good. Awesome. Thank you very much for your help there. Keep going. Want to make sure. Sorry, I'm just scratching. So the first question I'm seeing, just so you know, if a question seems to be like particularly very factually specific, what I'll probably ask is that the person who submits the question contact us directly. But otherwise, I'll try to address it here. First question, an auditor read from what she called her personal notes while presenting to the town board. Those notes were not posted prior to the meeting. Are those notes subject to FOIL? Going back to the very beginning of our conversation, a record subject to FOIL is any information in any physical form whatsoever. You know, calling it a personal note does not take it out of the realm of the Freedom of Information law. When we're working as public employees, I'm sure we all take personal, if you want to call it that, personal notes all the time. That doesn't mean it's not a record subject to FOIL. I can send my coworker an email saying, hey, do you want to go out to lunch later? That's clearly something of a personal nature, but if I'm using my work issued computer and sending an email to my coworker on their work issued computer, I'm creating a record subject to rights of access under FOIL. If I am in a meeting and I start taking notes at that meeting, I'm creating a record subject to FOIL. Do all of those records need to be disclosed necessarily? No. They're saying you review them for content to determine whether those records fit within any of the permissible grounds for denial, but they are records subject to FOIL. Someone asked if the regulations I referenced available on the website. Yes, they are. On our website at that top of that screen that I referenced at the beginning, there's a drop-down box. If you go to the Freedom of Information Law drop-down menu, you will see a reference to our regulations. Someone asked if an agency is required to translate a document, and the answer to that, in my opinion, is no. That would be creating a new record, translating a document. I mean, there may be obligations to translate records under other statutes, but not under the Freedom of Information law. So another person asked, to what extent are agencies permitted to perform quality assurance on or preemptive clarification of records? Well, agencies can do that, but that can't slow down the FOIL process. So for example, if someone requests a record, the record that exists at the moment the FOIL request is made is the record that needs to be reviewed to determine rights of access. Agencies should not be changing a record after the request is received. That's not to say that when an agency discloses that record, that it can't advise the applicant that these numbers have not been reviewed for quality assurance or something of that nature. And maybe the agency discloses both versions. They disclose the version that existed at the time the request was made, and also a follow-up saying, hey, we've reviewed those numbers and we just wanted to provide to you an updated version that reflects what we believe is more accurate information. But the record that exists at the time that the FOIL request is made is the record that has to be reviewed to determine rights of access. Another good question is, are records in the subject matter list available via FOIL? Not necessarily. So going back to a school district, a school district's record or subject matter list is going to include student education records. Those are records that it maintains, but that doesn't mean that those records are available in response to a Freedom of Information Law request. Someone asked, who gets to determine what is reasonable under the circumstances? I think I mentioned a little bit later in the presentation, maybe not at the time that this question was asked, but reasonableness is very subjective. That's why there's disagreements about what reasonableness is, and also why, particularly in terms of time limits, why there's an appeal process relating to that. So maybe the records access officer issues a determination as to, or sends out an acknowledgement letter with a date certain that they believe is reasonable under the circumstances. The applicant then has an opportunity to look at that and either say, yeah, I made a really big request. I understand that it's going to take 2 months to process my request. On the other hand, the applicant could have made a request for something really simple. And maybe they made a FOIL request for meeting minutes from town board meetings for the past 6 months. That's a fairly simple request and should be able to be processed pretty quickly. And the records access officer responded by saying, we'll get back to you in 3 months. The applicant may very reasonably decide that they're going to challenge that with an appeal. So there's a review process, but essentially the answer to your question is that it's subjective, but in general, the person who makes the determination at the first level is going to be the records access officer, and then the applicant has the right to challenge it. What about extremely broad requests, such as every file that mentions pertains to John Doe? In my opinion, that does not reasonably describe the record sought. To some extent, most agencies are not going to have a record keeping system that allows it to identify with minimal, I shouldn't say minimal effort, without exerting more than reasonable effort into locating every file or record that references a particular person. That just doesn't reasonably describe the record sought. There are other situations, for example, where a person has requested every email sent or received by a particular public employee over the past 5 years. That does not, probably doesn't reasonably describe the record sought because it's so incredibly broad. And also there's case law that addresses situations like that, where the courts have raised the possibility that a request could go beyond the scope of what FOIL intended, that it entails such a Herculean, I believe it used the term Herculean effort in terms of gathering and reviewing those records for rights of access. So for example, if someone came to me and wanted every email that I sent or received over the past 5 years, it's thousands and thousands and thousands of emails that I've sent or received in the past 5 years, many of which are subject to permissible grounds for denial. And in general, I'm not trying to protect myself, but there may be other people involved where the contents of my communications would cause harm to someone else if I disclose them. So I need to be very careful. If someone made a FOIL request to me for those types of records, it would take probably years for me to review them. And there's case law out there that says requests of that nature likely can be denied on the grounds that it goes beyond the scope of what FOIL intended. Question, are the administrative records of the judiciary available via FOIL? the example, so this is sort of two different questions, because the first part of the question is, are administrative records of the judiciary available via FOIL? And the example given is an example to seal records of a court case. Well, the example doesn't fit within the first part of the question. Administrative the records of the judiciary are records like, for example, that I might say like financial records, maybe payroll records, personnel records, that type of thing. Like, for example, the overarching administrative body that oversees the court system is the Office of Court Administration. They're the administrative arm of the judiciary, and the Office of Court Administration is subject to the Freedom of Information law. If you have a town court that is housed within, obviously, a town, perhaps the town, the judge and the clerk's personnel records might be maintained separately, not by the court, but by the town itself, either by the clerk or the supervisor. Those administrative records would be subject to FOIL, but an application to seal records of a court case is not an administrative record. It's a judicial record. It's a court record. So that record would not be available under FOIL. Someone asked, are municipal audit findings management letters subject to FOIL? I'm going to just let you know that every time someone asks me if a record is subject to FOIL, the answer is going to be yes, because the definition of record under FOIL is incredibly broad. So you make a request for a record, the agency must start with the assumption that all records are subject to FOIL, and then it's permitted to determine whether any of the permissible grounds for denial apply. Someone asks, are unpaid public library board members considered public employees for purposes of protecting private information, such as home addresses and personal phone numbers? Here I would not use the term employee, but official. So it's a good point. I think earlier I probably talked about not being required to disclose the home addresses of a public employee. This would also apply to a public official, such as an unpaid board member. Someone asked about issues at the federal level. What are the public information ramifications from the current record gathering efforts from DOJ? That has nothing to do with the New York State Freedom of Information law. That's a federal issue, as concerning as it may be to many people. It has nothing to do with the New York State Freedom of Information law. A complaint about an appointed official sent as a public letter to the agency to be read at a public meeting of the agency, is it foilable? Again, all records are foilable. And there's a question about whether it's inappropriate for executive session. So let's start out. A complaint about a letter that's sent to, let's say, a town board. So the town is the agency, the town board is the public body housed by the agency, or the governing body of the agency. You've got a letter that is sent to the town board about one of the town employees alleging misconduct. It's a complaint or alleging misconduct. The letter is a record subject to rights of access under FOIL. Is it required to be read at the public meeting? Absolutely not. You can ask that it be read at the public meeting, but there's absolutely no obligation on the part of the agency to read it at the public meeting. To discuss a complaint against a public official, is that appropriate for executive session? Yes, probably it is. You could be discussing matters relating to the employment history of a particular person, matters relating to potential disciplinary actions relating to a particular person. So yes, executive session might come into play. And it's not that records aren't foilable. So try to flip those questions on your head. Don't ask yourself, is this record foilable? Don't ask yourself, is this a public record? Ask if any of the permissible grounds for denial might apply. Someone asked if I have a copy of the slide that was not included in the PowerPoint printed on the 20th. You know what, I think you're right. I think I may have added it after the fact. The public employee notification policy, information about that is available on our website. So if you go to our opengovernment.ny.gov, it may be on our homepage. I'm just going to pull up. I don't think you'll be able to see, but hold on just a second. It's under committee news. So on our homepage, you're going to go to the menu item titled news. Then you're going to go to committee news and scroll down. You're going to see a section. The first one you'll see under news is FOIL Advisory Opinion 19867. And it says advisory opinion regarding new FOIL notification policy requirement. So that's where you're going to want to look for that information. I'm going to give you a link here in the comments. Just a second. One moment. Oh, sorry, wrong place. I don't want to send. I wanted to send it to everybody. There, I just sent a link to that public employee notification policy in the tab feature. Someone asked, after a contract is awarded, can the rejected bid be disclosed? There's no prohibition on disclosing rejected bids, and in fact, they are again record subject to FOIL, and unless you can assert one of the statutory grounds for denial, such as trade secret or substantial commercial injury, those rejected bids must be disclosed, or rejected proposals. Text messages are foilable, yes. Electronic communications, not via email, yes. If they're sent in your official capacity, if you're a public employee sending a text message relating to your public job, they are record subject to FOIL. If you're sending an email, regardless of whether you're using your personal device or a government issued device, if you are sending a communication relating to your work as a public employee or official, you are creating record subject to FOIL. If a state grant is awarded but the contract's not signed, can all the records leading up to the award be withheld? You have to make an argument that disclosure is going to impair contract awards. Can agency plainly not respond because it feels that the records request is not reasonably described, with the assertion that the law does not govern this question confuses me a little bit, but an agency can refuse to respond to a request on the grounds that the request does not reasonably describe the record sought, but the agency is also obligated to work with the applicant to attempt to identify what is being sought. Must an agency provide the reason for exemption of redacted information? I think we already talked about this. Yes, a single word redacted is a denial of access that has to be explained. It's a denial of access. Someone talks about mental hygiene law governing access to information to qualified individuals. It's not FOIL. When another statute governs access to a record, the agency complies with another statute, and access to those records is not governed by FOIL. You cannot make a FOIL request, for example, for mental health records, ever. Access to those records is governed by mental hygiene law. Does the records access officer have the authority to search agency staff email, or must they rely on those official representations regarding what they have or do not have? That is agency specific. It's a process question, not a legal question. Are agencies required to provide or post their updated holiday schedule? That's not something that's governed by FOIL. And the same attorney who drafted and advised the original denial advise and draft the denial of the appeal. An attorney can provide advice to both parties, is what I'm going to state. A town attorney, for example, can provide advice to the records access officer and can provide advice to the FOIL appeals officer. Can an agency say that the records access officer is only in the office once a week, so time limits will be based on when the officer is in the office? No, time limits are based on statutory definition of calendar days and business days. So for records, if you have a small municipality where for example, town clerk only works 2 days a week, it's not relevant. The agency still is obligated to respond or acknowledge a request within 5 business days, and business days are determined by statute as essentially Monday through Friday except for federal holidays, state holidays. Someone asked about when is the cost for a third-party vendor unreasonable? That is not addressed by statute. An agency convert electronically stored information into a PDF in response to a FOIL request. I already answered this question earlier. How long does an agency need to preserve board minutes? That's not addressed by FOIL. It's addressed by the New York State Archives Record Retention and Disposition Schedule. Can a school district withhold a school bus camera footage when requested by a parent of their child citing privacy concerns to other students? That's probably one, is that it could be governed by FERPA if it's a record that identifies students, and also it could raise personal privacy concerns. Even if one of the children on the bus is your child, and there are other children that have privacy concerns. If everybody can be, but your child can be sort of blurred out, that might be something that the school district's required to do. But school district is under FOIL permitted to take into consideration other children. The information, the presentation was included. Someone asked about whether it was available someplace. I have copies of similar PowerPoints available on my website, as I mentioned it earlier. It's under the section called I would like to do training material. In addition, when you registered for this, you should have been provided a copy. I did make a few updates to it since I sent out the registration information, but when you registered, you should have been provided access to the PowerPoint. If a single source is constantly submitting FOIL requests that seem unfounded, is there any recourse for the agency? That is a very difficult question. There's nothing in the statute that prohibits a single individual from submitting multiple requests, even a large number of requests. Is it allowable to refer one to a website to view a subject matter list? Certainly. If you have records as an agency, if you have records that are available on your website, the first step you should do, especially if you receive a request by email, is to let the person know, hey, did you know this information was available on our website? And then you provide a direct link to those records. Not just say it's available on our website, but provide the direct link to where those records are. If the person who's requesting the records doesn't have access to that website for some reason, maybe they're just not computer savvy, maybe they don't have a computer, whatever the case may be, if they want paper records, you have to ultimately give them paper records. But it always makes sense to point them to your website first. There is no time limit for providing a certification, but assuming that, for example, a diligent search has already been conducted, there's really no reason why any agency, there should be any significant delay in providing a certification that an agency does not possess the records sought, or that they cannot be found after a diligent search, but their statute does not contain a time limit. If the FOIL request provides a flash drive to copy files to, would it be acceptable to request a new flash drive if one is provided? Let me reread this question. If the FOIL requester provides a flash drive to copy files to, would it be acceptable to request a new flash drive if one is provided by the FOIL requester with the fear of virus contained? I don't quite understand this question. The first thing I'll say is, if you as an agency do not feel comfortable taking particularly an unwrapped flash drive and putting it in your computer, then don't do it. You're not required to do it. You may require that the applicant provide their own sealed flash drive, or you may require that they buy one from you. But again, you can only charge them what it costs you. There's, you're not getting any extra money from the deal. Do you have the right to demand a rolling production? No. Do I think it's a reasonable thing for an agency to do, to provide a rolling production? But no, you don't have the right to demand it. Is there a way to protect the identity of the individual requesting a FOIL from retaliation by an agency or government official? This is not something that is addressed by the statute. person who makes a FOIL request is creating a record subject to FOIL. If they are concerned about disclosing their identity, they have the right to make a request anonymously. If a public employee was disciplined and terminated by a town board resolution in which the employee was identified as employee number if FOIL, does the records access officer have to identify who that employee is? The town has to provide access to existing records. They don't need to answer questions. They have to provide access to existing records. So a request for a record that's, for example, the letter of termination addressed to employee number identified during this specific meeting would be a FOIL request that could be made. If you would like an updated version of the slides, just shoot me an email. I'll send it to you. But again, there's only just a couple of extra slides. The information available that was in those extra slides is available on our website. But certainly, if you'd like a copy of the updated version, feel free. And in fact, if you just even want to hold out for a little while, give me like a day, and I will ask our IT staff to put this version of my PowerPoint, the one that I use today, on my training material website. So again, if you go to opengovernment.ny.gov, scroll down the page a little bit, you're going to see a section that says, I would like to view training materials and recordings. There you'll see a link to both my open meetings law and my FOIL PowerPoints. Actually, I think they're in PDF version, but it's the same thing, same material. And today I will put in a request to my IT staff to have the most updated version of those PowerPoints updated to our website. Skimming through a couple just nice comments, which I appreciate. Thank you, thank you, thank you, thank you. Okay, I think that was the end of the questions. I apologize. Hopefully I got to everybody. I really want to thank everybody for joining me today. And I hope it was useful. If anyone is so interested is going to join me this afternoon, I look forward to having you back this afternoon to talk about the open meetings law. I will get that information up, the new PowerPoints up on my website, but if you want them in the interim, you feel free to shoot me an email. I hope everyone has a wonderful day. Thank you very much. Bye-bye.